The employment relation, always something new. The relationship between entrepreneur and employee is always shaped by many aspects, and here today we touch on some of them. We hear politicians talking about minimum wage, but in the meantime, judges give important indication in this sense. With no less than 6 judgments of the October 2023 of the Court of Cassazione, based on Article 36 of the Italian Constitution, it was established that in the event of a dispute between a company and the worker on the amount of the salary, the judge can disregard a collective agreement, even if it is stipulated at a national level and signed by the most representative trade unions. Furthermore, the judge can apply in place of that used by the company and challenged by the worker the higher remuneration provided under another similar collective agreement and for similar tax, and can do so ex officio if the worker has provided evidence of the insufficiency of the salary. Well, what should I say? Rather a law that it is often badly drafted, welcome regulation by case law. The decision of the judges obviously does not preclude the sovereignty of Parliament, and Parliament can always approve specific laws. If the employee has rights, he also has duties. He must never use company tools for private purposes. Cars, personal computers, telephones, only if allocated for mixed use, work and private, may be used outside work. The risk, otherwise, is redundancy. This was established by the Court of Cassazione in October this year as well. Beware, however, of the employer behaving badly. Employees must always be treated with great respect. It is against the law, and even the single action can be sanctioned. There is no need for a plurality of acts, but a fact committed, even an isolated one, which can be qualified as an illicit act and which entails the violation of the employee's constitutional protected interests, psychophysical integrity, dignity, personal identity, participation in social and political life, is sufficient. In the case in question, it was a stressful control modality, which, for the reason given above, turned into a violation of the law, resulting in an obligation to pay compensation to the employee. It has been a month full of interesting case law pronouncements, but the conclusion is that rights and duties always balance each other, and that it always takes some common sense on everyone's part, as well as a good lawyer to give the right advice.